right, hello friends, and welcome back to another episode of the Liberty Weekly podcast. I'm your host, as always, Patrick McFarland, and this one is episode 74. That is libertyweekly.net/74. You'll find the show notes page there, along with the video version, which is the the version that you should be watching, as I've been saying for the past few weeks here. Today we're going to be turning from foreign policy issues, and today's supposed to be a short episode, so you can get after me if it's too long. But we'll be turning from foreign policy issues back to the domestic front. There was a ruling from the Supreme Court yesterday in the Murphy v. National Collegiate Athletic Association case, so Murphy v. NCAA, on the issue of sports gambling. And this is, well, I'll get into that just after a few brief announcements here, but so first, just to outline the episode, I want to go through the opinion, go through some analysis on the opinion, and then talk a little bit about the 10th Amendment and talk about the issue of state sovereignty, give you some background on that. But first, the announcements. I finished law school yesterday morning. I took a final on Sunday that was probably the hardest final I've ever taken in the history of my life. Which was really stupid, and I was actually kind of mad about it because it's like, come on, man, you can't cut us a break. I've had you for 3 classes, my professor. But anyways, that's over. I'm sure I'll pass. And so just getting ready for graduation, which is next Sunday, the 20th, and I'm super excited about that. Obviously, who wouldn't be? But also, in addition to graduation being on Sunday, this marks the first year, the official first anniversary of the Liberty Weekly podcast, which started in all the way back May of last year, and started with co-host Jeremy McCullum, who has been I guess he's still the perennial. He's always the co-host, but he just doesn't appear on the show anymore, just because life happens. And so I'm trying to plan to do something special for the 1-year anniversary. I'm spinning a lot of plates because bar prep is going to start, where I start studying for the bar exam the Tuesday after graduation. So no wasting any time, I suppose. So I'm trying to think of something special to do, so be prepared for that. I have a really exciting week coming up. Rayford Davis has agreed to be interviewed by me on Thursday, so I want to ask him, as a former police officer, about as I'm starting my professional relationship as a voluntarist with our principles, how do you reconcile those principles with interacting with the real world and interacting with police officers and legal professionals? So I'm very excited to be getting some answers from him, to get his take on it. And I'm excited to bring him to you, the audience. He's a former police officer turned voluntarist. And honestly, him being on the show is very much overdue. So looking forward to that. Also, I'm trying to plan an episode with Tony Rockamora and Invalid Beard over at Don't Waste Your Hate. I'm excited about that. We're going to be talking about, I think, exploring more the issue of how libertarians should feel towards police and military. And so it's going to be, when I'm alone, I always put my foot in my mouth, and I feel like I've done that on previous episodes. So I really want to bring in, different perspectives. We'll probably go over how different types of libertarians feel about police and military and try and tease those apart. It's going to be a hard conversation, but I think it's a necessary conversation to have. And so we're looking forward to that. I don't think there's any other announcements. I'm sure I'll think of something after the fact. But without further ado, let's get into this episode here. This is a rare win for the 10th Amendment, and we'll get into that as well, an opinion from the 10th Amendment Center. But it is a rare win, and within it you have in the win, this ruling, the Supreme Court ruling, actually will be very interesting to see how it applies to concepts outside or issues outside of gambling. As we'll see in this opinion, it changes the way that the First Amendment is interpreted with the courts, and it'll be interesting to see, as people sue, given this decision, how the court will rule, because this will create issues with sanctuary cities and marijuana legalization. So it doesn't just bode on this. So, but to dive into the opinion here, here's the SCOTUS blog. This is probably your one-stop shop here. Murphy v. NCAA. This is a New Jersey. Does concern New Jersey, but this case was filed, I think, in 2016. Right here. Here was the petition in 2016. So, anytime there is a Supreme Court case, and in this show, I want to be able to hand you the tools to interpret this for yourself, because these opinions, as I've said, they're written in English. To be a proactive participant, I don't want to say participant in the political process, but to be an informed person and know what's going on, if you want to follow the Supreme Court, go to SCOTUS blog. They'll break it down for you, and you can start reading the opinions for yourself and reading the commentary on those opinions and educating yourself about what's happening. So this is just to instruct you guys on how to read this. This is the docket number, just the one that the Supreme Court assigns the cases. This is the opinion below. So in the federal court system, there's federal district courts, and then there's also the appellate courts. And this is from the Third Circuit Court of Appeals. And in order for it to become a Supreme Court case, the Supreme Court has to agree to pick it up in what's called a petition for a writ of cert. And so this was the one that was issued in this case. So the argument was heard December 4th of last year. The opinion was issued just yesterday. The vote was 3-6, striking down the federal law. And Justice Alito authored the lead opinion on the case. And this is the term in which the case was heard. So this is the holding in the case. Provisions of the Professional and Amateur Sports Protection Act that prohibit state authorization and licensing of sports gambling schemes violate the Constitution's anti-commandeering rule. No other PAPSA, that's the name of the law, no other PAPSA provisions are severable from the provisions at issue. So that's the holding. The judgment here is the law was reversed in a 6-3 opinion authored by Justice Alito. Justice Alito delivered the opinion of the court, and there's a whole bunch of concurring and dissenting opinions because that's just the way the court ruled. So Chief Justice Roberts and Kennedy joined in Alito's opinion. Thomas Kagan and Gorsuch also joined. Justice Breyer joined as to all of the concurring opinion except a certain part. And then Justice Thomas filed his own opinion. Justice Thomas, along with Gorsuch, being two of the most conservative members. And I don't want to say liberty-friendly because the Supreme Court is not a friend to liberty, just the existence of the Supreme Court. Sorry, I had a noise there. I apologize for that. So that's just the overview, and here's all the dockets here. Look at all these amicus briefs filed. And amicus briefs are briefs that are filed by third parties that are not a party to the lawsuit, but are concerned with the way that the law is going to be shaped going forward. And the Cato Institute files a lot of amicus briefs, and you can see all these different organizations filing briefs. Online gambling and sports gambling and just gambling in general is a very large interest to a lot of people. And so there was a lot of opinions that were given on it. So just to break down the opinion here, here's legal analysis from Amy Howe. Again, all these links will be in the show notes page. Opinion analysis, justices strike down federal sports gambling law. Updated. So she begins, Amy Howe, with her analysis. The 10th Amendment provides that if the Constitution does not either give a power to the federal government or take that power away from the states, that power is reserved for the states or to the people themselves. The Supreme Court has long interpreted this provision to bar the federal government from, quote, commandeering the states to enforce federal law or policy. Today, the justices ruled that a federal law that bars states from legalizing sports betting violates the anti-commandeering doctrine. Okay, let me read that again. Today, the justices ruled that a federal law that bars states from legalizing sports betting violates the anti-commandeering doctrine. Their decision not only opens the door for states around the country to allow sports betting, but it also could give significantly more power to states generally on issues ranging from the decriminalization of marijuana to sanctuary cities. So bing, 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 there you have it. There you have the importance of this case beyond just sports gambling. And one issue here, just right off the bat, is the issue that I take with it is that not only does this decision allow private entities to come in and to legalize sports gambling for private entities, but it also does open up the ability of the states to create their own state-sanctioned gambling schemes. And for reasons that I shouldn't explain, that's not... I mean, it's a good thing that the states get this little position that they can take, this little more power, but at the same time, you are granting power to the states to have their own gambling operations, and that's state sanctioned. I'm against that, but still, I think you prefer the government that's more local to the people, closer to the people. But it does open up the ability for private entities to have gambling. So interesting. There's another interesting part. I can't wait to get here. So here's the next paragraph. The federal law at issue in the case is the Professional and Amateur Sports Protection Act, or PASPA, which dates back to 1992. The law bans most states from, among other things, authorizing sports gambling. It carved out an exception that would have permitted New Jersey to set up a sports betting scheme in the state's casinos as long as the state did so within a year. But it took New Jersey 20 years to act. In 2012, the state legislature passed a law that legalized sports betting in opposition to PASPA. The NCAA and the 4 major professional sports leagues went to court arguing that this 2012 law passed by New Jersey violated PASPA. The lower federal courts agreed, prompting the New Jersey legislature to go back to the drawing board. And in 2014, it passed a new law that rolled back existing bans on sports betting, at least as they applied to New Jersey casinos and racetracks. The NCAA and the leagues returned to court, arguing again that the new law also violated PASPA, and the U.S. Court of Appeals for the Third Circuit again ruled against the state. The funny thing about PASPA is that it was, from what I understand, at least from reading this, it was a federal ban on gambling, just across the board. Except we're going to make these exceptions for Nevada, the state of Nevada, for obvious reasons, and the state of New Jersey for Atlantic City, also obvious reasons. So kind of hypocritical. Oh, gambling is wrong, but we'll keep it for, Nevada and New Jersey because reasons. So the Supreme Court agreed to consider the state's constitutional challenge to PASPA, and today the court reversed. In a decision by Justice Alito, the court began by explaining that the anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution. So in the second half, I'm gonna get into maybe in the first half, I'll get into the actual opinion and see this language. This language is just so Supreme Court, and it really irritates me. The anti-commandeering doctrine may sound arcane. Okay, it's arcane to prohibit the federal government from infringing on, from forcing the states to enforce federal law. That's arcane. I mean, that's just the state of the Supreme Court right there in a nutshell. The anti-commandeering doctrine may sound arcane. It's not. I don't see how any of that sounds arcane. Anyways, he says, but it is simply the expression of a fundamental structural decision incorporated into the Constitution. The decision to withhold from Congress the power to issue orders directly to the states. Yeah, that's not arcane, Justice Alito. And that, the majority continued, is exactly the problem with the provision of PASPA that the state challenged, which bars states from authorizing sports gambling. It unequivocally dictates, this is a quote, it unequivocally dictates what a state legislature may and may not do. It is as if, the majority suggested, federal officers were installed in state legislative chambers and were armed with the authority to stop legislators from voting on any offending proposals. A more direct affront to state sovereignty, Alito concluded, is not easy to imagine. So this is the correct decision. And I'm obviously not a fan of the Supreme Court. if we could go way back into the truth about judicial review. That is a Liberation Library episode. Oops. Review. Sorry, my microphone is in the way. I apologize for that. Here it is, the truth about judicial review. I'd also get into, you know, the nullification episodes that I've done. I just recently did an episode on this issue, so check that out. libertyweekly.net/LL3, the letters LL and the number 3. Also, episode 73. Not my best episode. 72. Not my best episode. Just a disclaimer. I'm not a big fan of this episode. On the other hand, this one is better. So, having determined that PASPA, the next step after determining that PASPA did violate the anti-commandeering clause, the Supreme Court moved on to the next decision of trying to decide whether the provision within PASPA, so PASPA is a big bill, it has different provisions in it. The Supreme Court, the provision at issue, the Supreme Court determined was unconstitutional. The next step was trying to decide whether, okay, because this one provision is unconstitutional, does that make the entire law unconstitutional? And that's called severability. And as the, what's her name? Amy Howe, as she explains further in the article, the Supreme Court then had to decide whether that provision of the bill was severable from the rest of the bill, whether we can only strike this provision as unconstitutional and leave the rest of it intact. And the opinion ruled that no, we cannot do that. This provision makes the entire bill unconstitutional. The unconstitutionality of this provision makes the entire bill unconstitutional. So that's just basically it. I also, I think it is interesting to note that the plaintiffs, and I believe they're the plaintiffs in this case, they're not the appellants because it would be Murphy would be the appellant. But it was the NCAA is the one that is seeking to enforce the federal law. They are appealing to the federal government to strike down, to enforce the law. Sorry, and Murphy wants to uphold the law. Or, my gosh, I'm sorry. See, these get confusing. So it is Murphy that wants the federal law to be struck down, and the NCAA that is appealing and wants the federal law to be enforced. It's interesting to me that so this is where you get your rent-seeking behavior, specifically, and this is in all of the major sports franchises are rent-seeking on the federal government because they do not want gambling surrounding their sports. So they're appealing to the federal authority in a rent-seeking type behavior in cronyist fashion. In a certain sense, you get these two parties, you know, fighting over federal power. All right, so here's the rest of the opinion. I'll include a link to this in the show notes page. Let's move on here to the 10th Amendment Center's take on this. And, okay, we'll get into that when we talk about the 10th Amendment in the second half. Let's see, we're doing good on time, 20 minutes. So here's the opinion. You get it from going to the first link that I'll put in the page. And I'll put a link to the opinion too. But all the way down here, this is the opinion of the court. You can read all the amicus briefs, and you can also read all of the briefs from the respondent, the petitioners. Chris Christie is involved, and the state of New Jersey, so that's interesting. Here's the opinion. These are the facts. There's a docket in the beginning of the opinion. So if you really want to get into the meat of it and get the history of it, here is the facts section. They talk about Atlantic City and about, I think, Nevada as well, just the history of gambling in general. Then we have the history of PASPA. Let me zoom in a little bit here so you can see a little better. And here's here's the legislative history of the 10th Amendment, if I can find it. This is the so when you go to law school, you learn how to do legal writing, and you hear all about the IRAC format. So when you're reading judicial opinions, it's always the issue followed by the rule, and then the analysis, and then the conclusion section. That is the formula for legal writing. Issue, rule, analysis, conclusion. It's formulaic. Everyone tells you just stick to that, stick to IRAC, and if you get really, really good, you can experiment with other forms. But generally, you'll get the issue, the facts, followed by the issue, then the rule. And so this is the rule section. In making this argument, the state relied primarily on two cases, New York v. United States and Prince v. United States, which are two very seminal cases, in which we struck down federal laws based on what has been dubbed the anti-commandeering principle. In New York, we held that a federal law unconstitutionally ordered the state to regulate in accordance with federal standards. And in Prince, we found that another federal statute unconstitutionally compelled state officers to enforce federal law. Relying on these cases, New Jersey argued that PASPA is similarly flawed because it regulates a state's exercise of its lawmaking power by prohibiting it from modifying or repealing its laws prohibiting sports gambling. The plaintiffs countered that PASPA is critically different from the anti-commandeering cases. Now, this is the plaintiffs arguing. Man, I hope I didn't get these tags messed up in the beginning. Like I said, it can be hard to keep track of the parties, so I apologize for this. I just only looked at this morning, so I'm not super familiar. But so the plaintiffs countered that PASPA is critically different from the anti-commandeering cases because it does not command the states to take any affirmative act. Without an affirmative federal command to do something, the plaintiffs insisted, there can be no claim of commandeering. The district court found no anti-commandeering violation, and a divided panel of the Third Circuit affirmed. National Collegiate Athletic Association versus Christie. So it looks like the original plaintiffs are the NCAA and other leagues that are suing Christie. It'd be Christie, who is the governor of New Jersey, to enforce the federal law. The panel thought it significant that PASPA does not impose any affirmative command. In the words of the panel, PASPA does not require or coerce the states to lift a finger. The panel recognized that an affirmative command, for example, do not repeal, can often be phrased as a prohibition. Repeal is prohibited. But the panel did not interpret PASPA as prohibiting the repeal of laws outlawing sports gambling. A repeal, it thought, would not amount to authorization and thus would fall outside the scope of the statute. The lack of an affirmative prohibition of an activity, the panel wrote, does not mean it is affirmatively authorized by law. The right to do that which is not prohibited derives not from the authority of the state, but from the inherent rights of the people. So there you get some of the court's reasoning. I would suggest that everyone read the opinion, but look here, I mean, it's really long, so I didn't have time to get into all of it. So I hope that what I've provided so far can give you guys just kind of a background on the case as you dive into it. And the ruling, you go in here and you get the reasoning. One thing I did want to highlight, I'm not going to go through all of it, obviously. Right here, this is here's the reasoning of the court. I'm going to read this just very quickly. The anti-commandeering doctrine may sound arcane, but it is simply the expression of a fundamental structural decision incorporated into the Constitution, i.e., the decision to withhold from Congress the power to issue orders directly to the states. When the original states declared their independence, they claimed the powers inherent to sovereignty. When the original states declared their independence, they claimed the powers inherent in sovereignty. In the words of the Declaration of Independence, the authority to do all things, acts and things which independent states may of right do. The Constitution limited but did not abolish the sovereign powers of the states, which retained a residuary and inviolable sovereignty. That's the Federalist Papers. Federalist number 39. Thus, both the federal government and the states wield sovereign powers, and that is why our system of government is said to be one of, quote, dual sovereignty. The Constitution limits state sovereignty in several ways. It directly prohibits the states from exercising some attributes of sovereignty. Some grants of power to the federal government have been held to impose implicit restrictions on the states. and the Constitution indirectly restricts the states by granting certain legislative powers to Congress, while providing in the Supremacy Clause that federal law is, quote, the supreme law of the land, anything in the Constitution or laws of the state to the contrary notwithstanding. This means that, there's the Supremacy Clause. The proper interpretation, in my opinion, of the Supremacy Clause is that any law made constitutionally is the supreme law of the land. So I don't think, a lot of people will quote the Supremacy Clause to say that the Constitution in the federal government is the supreme law of the land, but no, in actuality, it's only a law made in accordance with the Constitution becomes the supreme law of the land. So, I mean, that really just depends on what the Constitution says and how you interpret it. So anything in the Constitution or laws of any state to the contrary notwithstanding, this means that when federal and state law conflict, the federal law prevails and state law is preempted. I don't necessarily agree with that. But we're talking about the Supreme Court here, so of course they're going to interpret it that way. So, although the anti-commandeering principle is simple and basic, it did not emerge in our cases until relatively recently, when Congress attempted in a few isolated instances to extend its authority in unprecedented ways. The pioneering case was New York v. United States in 1992, which concerned a federal law that required a state under certain circumstances either to take title to low-level radioactive waste or to regulate according to the instructions of Congress. So I'm not going to get into all the weeds in the picker bush here. You can if you want to read the case. But they're just going to go through now. This is the beginning of the actual opinion here at 3A on page 14 right here. So go through and read what Alito has to say. But this really does reflect... Well, I'm going to get into this in the second half. So right now we're going to do a little break. We'll get into the history in the second half of the 10th Amendment of the 10th Amendment, get into interpretations, and come at it from an angle that is not Supreme Court centric. But first, I wanted to get an update our DonorSee project. DonorSee is currently really doing well in raising revenue for expanded operations, and I think that's excellent. Just to check up here on...
Hi everyone, this is Nancy Kiden. She's mother of two. She got pregnant when she was 14 years old. Now she's struggling to raise two children single-handedly. She has...
This was the project that we featured in our last episode of the Liberty Weekly podcast. That was 73 with Kyle Anzalone. Excellent episode. I'm very proud of that one. It didn't do so well on BitChute though. However, so this project was funded. I'm not sure if any of you guys funded it. If you did fund it, I would ask you to put a comment here, and I will feature you in the next episode. So there's no comments, so I'm assuming that no one from the Liberty Weekly podcast funded it. If to the contrary, I'm wrong, if one of you did fund it, please send me an email at patrickmcfarlane@libertyweekly.net, patrick.mcfarlane@libertyweekly.net, and make sure you spell my last name right, McFarlane. So please leave a message here if you did. Farlane. Please leave a comment here if you did. This project was fully funded, so yay, yay. Next project, I'm going to leave a link to this in the show notes page as well, is someone named Jessie Schwartz put this project up. She's going on a mission trip to Uganda. There's $124 left. She's looking for funds to work full-time. She will be opening up a house to young Ugandan women. She will walk alongside of them, discipling them. It is a Bible, so if you're an atheist or non-religious, maybe consider a different project, I suppose. But at the very least, I mean, she's doing good work for these people. Maybe they need religion. I have no idea. I'm not getting into that. But they are in need. So she's going there to help do Bible study, teach them English, helping them start small businesses. This is the most important part, to get them on their feet to support their future families and kids. So consider giving to this project in Uganda. I'll put a link in the show notes page. Also, this is through DonorSee, by the way. But if you do give, please comment here and tell just say that I sent you from the Liberty Weekly podcast, and I'll feature you in the next episode and your gift. And so I think this is a great thing. I'll be highlighting DonorSee projects in an ad spot in episodes in the future. So check the show notes page for that, and please consider giving to this this worthy cause. Okay, so next I wanted to get into, let's see, we're at 30 minutes here. I don't want to keep you too much longer, but this is my constitutional law horn book that I use for my con law class. You can see all my little tabs in it and stuff. This is written by Erwin Chemerinsky, who is like a socialist butthole. Excuse me for those words. I think he's very liberal, and he's wrong a lot of the times on certain interpretations. But he wrote this horn book, which my friend who is really, really into constitutional law says is horrible. So I don't know why I'm using it, I suppose, but he does outline. I have used it before. It really helped me to understand these certain issues, and I'm going to be using it to get the liberal perspective on what the 10th Amendment is. So here's where he goes into the 10th Amendment. I'm just going to be reading from it here quickly. The 10th Amendment and federalism as a limit on congressional authority. Competing approaches to the 10th Amendment. The 10th Amendment states the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. The key question about the 10th Amendment is whether it is a judicially enforceable limit on Congress's powers. Can federal laws be declared unconstitutional as violating this constitutional provision? Over the course of American history, the court has been inconsistent in answering these questions and has shifted between the two different approaches. I believe this is different from nullification, although it's not too different. So the states could nullify using the color of the 10th Amendment and say, okay, the federal government was not delegated this power, therefore it's unconstitutional and we're not following it. It's null and void to no effect. And all they would have to argue is that it's not authorized in the Constitution, because the theory of the Constitution is that we're creating this federal government and only giving it the powers that we expressly delegate to it. So therefore, if the federal government wants to do something, they have to find that within the Constitution in order to do it. And if you're going to nullify as a state, the 10th Amendment is your most important mechanism. I misspoke earlier just now. This would be one of the most important things, because you're using the color of the 10th Amendment to point out and say, okay, you're doing something that was not delegated to you, therefore we don't have to follow it, and it's unconstitutional. We are not waiting for the courts to rule on this issue. We are doing it ourselves and saying, hey, this is unconstitutional. And that's what Mike, I'm going to butcher his name, but that's what we're going to talk about in this 10th Amendment case that Mike Marahi wrote. He praises the fact that the New Jersey legislature would knowingly create a law that violates the federal dictate of the PASPA. So, one approach is that the 10th Amendment is not a separate constraint on Congress, but rather is simply a reminder that Congress only may legislate if it has authority under the Constitution. Under this approach, a federal law never would be found unconstitutional as violating the 10th Amendment, but it could be invalidated as exceeding the scope of Congress's powers under Article 1 of the Constitution, or for violating another constitutional provision. So that is the more liberal interpretation. The alternate approach is that the 10th Amendment protects state sovereignty from federal intrusion. Under this approach, the 10th Amendment is a key protection of states' rights in federalism. The 10th Amendment reserves a zone of activity to the states for their exclusive control, and federal laws intruding into this zone should be declared unconstitutional by the courts. As described below, in the 19th century, the court took the former position and held that a federal law was constitutional so long as Congress was acting within the scope of its authority. In the first third of the 20th century until 1937, the court adopted the latter view and found that the 10th Amendment reserved to the states control over production, and federal laws attempting to regulate production were unconstitutional. From 1937 until the 1990s, the court shifted back to the former approach. So you see the politics of the Supreme Court going back and forth. In fact, during this period, there was only one case where a federal law was found to violate the 10th Amendment. So, let's go here. From 1937 until 1990, there was only one case where a federal law was found to violate the 10th Amendment. I say again, from 1937 until the 1990s, the Supreme Court only violated one federal law as under the 10th Amendment. So if you think the Supreme Court is going to protect state sovereignty, you're mistaken. Or if you think the Supreme Court is going to protect individual rights. And this case was later expressly overruled. So there was only one case during that time where they found it to violate the 10th Amendment, and that case was overruled. So, but in the 1990s, however, the court resurrected the 10th Amendment as a limit on congressional power. So there you have it. Since the 1990s, the Supreme Court has actually been more friendly to the 10th Amendment, and we're trending in that direction. And the whole point of this episode is to say, and we'll conclude with the 10th Amendment Center, this article, the whole point is to say that this is just another step in the direction that has very, very interesting and foundational shaky implications for hot issues right now, like sanctuary cities and like marijuana legalization. And I think it's very ironic that those two things, sanctuary cities and, well, actually all these three things, sanctuary cities, gambling, and medical marijuana are all liberal issues. At the same time, those liberal issues, those left-leaning issues, they're using the color of the 10th Amendment, which is a conservative doctrine, to enforce and advocate for those issues on behalf of the states. That's very interesting. Usually it's conservatives that like state sovereignty. So to get into this, here is Mike Marahi's 10th Amendment Center piece. I hope I pronounced his name right. Apologies to Mike if he sees this. But earlier today, he writes, the Supreme Court issued its decision. I already went over all the facts. So the 10th Amendment Center generally advises against a strategy focused on going to federal courts to limit federal power because, as I said, it doesn't work. In the period from 1930 to 1990, there was only one federal law that was deemed unconstitutional by the Supreme Court. As it is usually ineffective or even dangerous for liberty. And oh, that's an interesting link. Let's follow that. Oh, okay. It's a video, sorry.
Running to federal...
Oh, I'm sorry. So, dangerous for liberty. But SCOTUS has been consistently correct when it comes to anti-commandeering. In a nutshell, the court has repeatedly held that the federal government cannot require states to use resources or personnel to help implement federal programs or to enforce federal laws. The principle dates back all the way to Prigg v. Pennsylvania in 1842, when Justice Joseph Story held that the federal government couldn't require states to help enforce the Federal Fugitive Slave Act of 1793. He said that it was a federal law and the federal government ultimately had to enforce it. So he goes through more of the benchmark cases: New York v. United States, Prince v. United States, and Independent Business v. Sebelius. And this is what was recounted by Justice Alito in his opinion. He went through these cases as well. So, and that is the trend in the direction of protecting state sovereignty in the last few years that I was talking about. These opinions provide a powerful tool for states to opt out of overreaching federal actions, including prohibitions on sports betting and nullifying them in practice and effect. So he goes through the case as well with some really meaty parts of the opinion he lists here. So go through this article. I'll include in the show notes page as well. But he basically says, what we need to do based on this decision is we need states to start nutting up, and we need states to start challenging federal provisions by nullifying them, or we need states to start writing lots of laws that challenge federal authority. That even though they know, as in New Jersey with the sports betting case, they know that they wrote a law that violated PASPA. They didn't care. That's what we need. That's what we need on behalf of the legislatures, and at every level is to disobey at every level, whether it's the state level, whether it's the county level, whether it's the township level, whether it's the neighborhood level, and whether it's the individual level or the household level or the individual level. That's what we need, and that's what we'd advocate for. And this case gives us more of a leg to stand on. It is one, look at these cases that ruled in favor of the states. It is just one more block in that chain. Now we need states to step up and press these issues like sanctuary cities, marijuana legalization. So, thanks so much for joining me for another episode of the Liberty Weekly podcast. Just as we're closing up here, check out the show notes page at libertyweekly.net/74. 74, yes. And I've also been resurrecting the email list. Been sending out a few updates. If you'd like to get on the email list, there is content there that does not appear on the website. So check that email list sign up by going to libertyweekly.net/email. I'll try and make that link live. That'd be no spaces, libertyweekly.net/email, EMAIL, email. Otherwise, you can go to the webpage and click on the email list sign up that is right in the horizontal bar, the first horizontal bar here. Also, consider giving to DonorSee. I think that's going to be a very important part of what I do with the show. My activism is putting our money where our mouth is when saying charity that can replace welfare. That's also important. Also, check out, how to support the Liberty Weekly podcast. That's at patreon.com/Liberty Weekly. Here's some bonus content you can see behind the scenes. The behind-the-scenes conversation with Kyle and Salone from the last episode. Also, more access to Scottish Liberty podcast and any updates and bonuses that I also have. So look forward to the interview I have coming out. That's Thursday morning with Rayford Davis. Also, I'm scheming something with, like I said, the boys from Don't Waste Your Hate. Really excited to get back on their show. And let's see, is there any other plugs I need to make? Amazon affiliate link, that's libertyweekly.net/Amazon. Do your regular Amazon shopping. If you follow me on Twitter at Liberty Weekly, you can see on the screen here, I've included I share the books that I get. Here's the last bit, Hooper's War and Generation Kill, I bought. There were a bunch of other books that I bought as well. So that's where that money goes, in case you're wondering. All right, well, thanks, everyone. I promised a short episode, and this one is 42 minutes, so I apologize. But we're going to end it there. So look forward to the next episodes coming out, and we'll see you later this week. Peace.